what can they do when trustees are performing the job poorly? And for whatever reason, my screen isn't coming up. Trust it to go to work all the way up until the very final, very final lecture. That's very annoying. There it is. Okay. And so that, I'm not going to labour that point. You guys are aware at this point. Beneficiaries do get rights. They get rights to to be considered for distribution, and a discretionary trust to get a right to receive income regularly for a fixed trust, and the right to receive income which has been allocated to them in a discretionary trust as well. You get all of the rights under the Trust Act to go through and compel trustees to do certain things, and as we'll see here, they could also get some rights in regards to ending the trust itself. And we went over this when talking about determination and termination of trusts. The rule in Saunders and Vautier, that idea that adult beneficiaries, and I will note that I use the word sui juris, which kind of doesn't make sense because adults are strictly speaking sui juris, but not under legal disability. In other words, not under things like powers of attorney or bankrupt. So that if there is only one beneficiary and that person is an adult and not under legal disability, they can demand the trust end. Now, it is kind of odd that these rules are in the general law. For one, I've never quite managed to get my head around it. And I would have studied this almost 10 years ago. Never really understood why this was. The rule in Saunders and Vautier is pretty clear. And it's going to trump the instrument. So if the instrument says, oh no, you're not going to get till you're 25. No. You are the beneficial owner. You can demand your thing, which is your item of property. You can demand or compel the trustees to actually go, give you your stuff, and you walk away. And it is an old rule, 150, 170 years old. But some of the derivatives are a little bit less clear. And I said, Tom sort of says it tongue-in-cheek, and Nicola similarly, and the texts, the two textbooks that we have are a little bit less circumspect about the rules. But for the purposes of what we're doing here, and for the purposes of your exam, we can assume that these rules can be taken as stated. And the first one in Gosling and Gosling is that idea that if everybody would be entitled under Saunders and Vautier, if there's just multiple beneficiaries, and they all come together and agree to end the trust, again, they are collectively the owners of that trust property. They can demand the trust end. Things start to break down when you don't have a trust that's going to end in entirety. That Whakatane Paper Mills case and Manfred and Mandrell. So they both tend towards the rule that where you, again, you're an adult, obviously you're sui juris, not under a legal disability, you can demand your beneficial interest be given to you. Now you can do that either if all the other beneficiaries consent, in other words they agree as to what the thing is that you're getting, and they are all also adults of sound mind, not under a legal disability. That's fine. But you can also do it without their consent, in theory, if you can do so without prejudicing their beneficial interests. So that can be done in a situation where things are fungible, such as cash. If there are 3 beneficiaries, $300,000 cash, it's not going to prejudice the others if they're sitting in a bank account. That's straightforward. Things, however, get more complex in the real world with other classes of assets, where, for example, there are 300 shares in a company. So there's 100 shares in a company, and there's 4 beneficiaries. In theory, if one of the beneficiary goes, they can just have 25 shares. In practice, though, we're aware under company law that membership and voting power moves as well. And so these can be situations where it's problematic because it can in some ways can actually prejudice the beneficial interest of others. If you're going to go and take a share and on-sell them. Or in the example of real property, if you want to split the property that is held jointly, in other words, a joint tenancy, for the beneficial interest of yourself and your siblings, if you want to have your share converted to a tenancy in common, which in theory can be disposed of independently. There's arguments to be made that that prejudices the existing beneficiaries' interests in some way. And so the courts are a bit more reluctant to go through and do that. Like I said, I found it interesting that this hasn't been mapped out in statute. I'm surprised, actually. But nonetheless, for the purposes of this subject, start with the rule and Saunders and Vortier, and Manfred and Mantrell, Gosling and Gosling. Okay, we talked about the ability of beneficiaries to use the knowing assistance and the knowing receipt rules in order to seek a remedy against third parties. Okay, that's in situation where there's been some form of breach. In other words, the property's been dishonestly taken. There's been a breach of fiduciary duty. You are trying to render the third party liable if they've knowingly received trust property. Again, Westpac and Savin. This is the first limb of Barnes and Addy. If they have actual or constructive knowledge, or if they knowingly assist in the breach. That's the second limb of Barnes and Addy. That requires actual knowledge. And Farah and Sadie construction, I talk about those, and we've gone over those a few times in the tutes. However, there are rights that you can have against third parties where property has been paid or delivered to them under some form of mistake. And that's what happened in Re Diplock. There it was a mistake of law. It was to do with a purported charitable trust with many charities listed, I think 139 charities, and quite a large sum of money. It was £250,000, which is a lot of money in the 50s, 40s, whenever this was. And so there, though, the courts did say that, look, you can actually recover this. That beneficiaries do actually have a right to go and make a claim. And the idea is that when things have been done, and we appreciate here, this is still a breach. If you've paid the thing out, you've done it wrongfully, negligently, accidentally, it doesn't matter, it's still a breach. And so the starting point is you go after the trustees. And I think it's a really important thing to get your head around here. All this is from Re Diplock. This idea of this difference between a personal action, an action in personam, and a proprietary action, an action in rem. You can elect to do one or the other, because there are going to be some situations where you're going to prefer one result over the other. You will ordinarily be wanting an action in rem if the person has assets. If they actually have assets but not much cash because they've gone and spent it all, for example, but they have assets that they've taken from the trust. And again, later I'll talk about the tracing remedy as well, which is where they've taken usually funds and converted them to assets. You can use the mechanics of the doctrine of tracing and equity to be able to get stuff. That is an action against the thing. When you're bringing an action against the thing, the fact that the person has no money really ceases to be relevant. Also means if you've got an action against the thing, that person becomes insolvent, or they leave the jurisdiction and can't be found. That's a more powerful way to really remedy the situation. And as beneficiary, you get to go through and make that election. And if you can't get things back from the trustee, you can get things back from third parties where things have been received, as I said, through some form of mistake, either a factual mistake, you paid it in the wrong bank account, or given it to the wrong person, or of law. And we remember from charities rules that if, for example, something wasn't given for an appropriate charitable purpose, gave it to somebody for the purpose of, I'm trying to think of a less silly example, holding children's birthday parties. Okay, now that's the starting point, and appreciate this is for situations where the third party is innocent. Third party is innocent, and the thing's been paid not through as a result of a fraudulent breach of fiduciary duty. It's going to be a negligent one. So that the scenarios where this comes up, you can go through and you ought to be able to tell in your exam which of the two you're going to go and talk about. Okay, and that point, I'll just re-emphasize that point. These are in Section 113, which is a relatively recent addition to the Trust Act, where they've taken the common law rules and just enshrined them in the statute. Relatively recently, I mean, it would have been the last 10 years. Yeah. Okay, so that you do need to note that as a beneficiary, you go after the trustees first. They're the ones held to the highest standard. You only go after the third parties when you've exhausted remedies against the trustees. And again, this is in situations where the trustees have made some form of error or mistake. Because, and that can also arise in, I'll come back to that. All right, so there is an excuse there as well. Was it 113 sub 3? That just essentially enshrines that rule, which comes from the common law. And it's pretty much the same line you would have heard as an excuse for equitable actions throughout your law degree, doing contract law, for example, and land law. Some aspects of commercial law for those that do that. And that's this idea of a third party taking things in good faith. So in other words, a bona fide purchaser for value. And in other words, they've materially altered their position. They haven't taken the thing for an undervalue. And it's going to cause some form of inequitable situation. Something that goes against good conscience, an unjust result. I probably shouldn't have used the word money in that slide. I think that words come from Tom, but it should be property in a broad sense. I'll fix that on the slide. Okay, now, so that's the rule for innocent third parties. Yes, you can get stuff back that's paid to them for some sort of mistake, or either a factor of law. First, you go after the trustees, and they can use this excuse here. If they've given or somehow acquired the trust property, they've done it for value. All right, now I think that Tina would have taught you guys what tracing was. I'm going to look around the room. Does this term sound familiar to anyone? I'm not getting any responses at all, so I'm going to assume not. Tracing is not, strictly speaking, a remedy. It's a mechanical series of rules in equity to allow the recovery of property that's been passed on in some ways or transformed in some way to something else. As if you think about just in terms of trying to resolve things. If you put yourself in the position of the courts of chancery, if we are trying to resolve a particular problem, here the problem is a breach of fiduciary duty, where a trustee has gone, trustee who has no money to start with, has taken the money, taken $10,000 from the trust fund and converted that into a Mazda RX-8. It would be silly if the courts couldn't go through, make an argument for that particular car to be passed somehow back to the person, the beneficiary in this case, of that particular trust. But that's not how things work at common law. So if we think about it, if there was a breach of contract, we're suing somebody, contract law is a right in personam, you get damages. It's only in equities jurisdiction that where you'll get things like injunctions and specific performance to recover unique goods or uphold certain types of clauses. Here, the courts have developed this mechanism to try and put things right. And these series of rules can actually go and impact third parties. Now, tracing, as I said, is not a remedy in onto itself. It's just a series of rules and mechanical steps the courts can take to be able to grab property that's been transformed in some way, either moved from person to person or converted into some other form of asset. And to use the tracing remedy, you've got to prove these three things. First of all, you've got to prove that this is or requires equities intervention. Similar to how when we look at specific performance in contract law, how the courts won't enforce it in order for specific performance where common law damages are adequate. Here, we are demonstrating or need to demonstrate that this particular remedy is required to bring an equitable and just result in equities jurisdiction. In other words, for the purposes of us, for a breach of fiduciary duty. Breach of fiduciary duty has caused property to be transformed in some way. So that's the first thing. We have to prove that equity has jurisdiction over this particular transaction. Secondly, we have to be able to identify the property itself. The phrase that gets used in the case law is dissipate. If the property has been dissipated, you can't use tracing. It's gone. You have to find some other way. And so that's the second thing. You have to be able to identify the property that's the result of this transformation. And it can be a series of things. You could, for example, if there's a breach of fiduciary duty, somebody could have taken the $10,000 cash, converted it into shares, then sold those shares, converted that into a Holden Commodore. And that's okay, provided we can see and identify that particular piece of property. And finally, like a lot of things in equity, it's not going to work, you won't be able to use tracing if it's going to create some injustice, be it hardship, be it unfairness, be it something unconscionable, or generally unjust. And by there, really think about the tenets of equity, the idea of going to the courts of chancery with clean hands. Think about the rules for latches and the other aspects that the maxims of equity that you've been exposed to throughout this course and last semester as well. Okay, and as I mentioned, the this idea of dissipation, and those are the case citations for that. This idea that, look, if you can't make this logical connection between the property that was taken as a result of the breach and what it's been transformed to, you can't use the tracing or the mechanical rules of tracing in order to seek a remedy that way. You can still try other aspects, but you can't use the tracing component as part of that, seeking that remedy. All right, now, in terms of your examinable material, it's very likely that you'll get a question that says this money has been taken and, for example, someone's purchased shares. That's a straightforward example of a situation where tracing is going to apply. Taken cash in the situation, or an investment asset of some sort, and converted it into another form of investment asset. If that can be easily identifiable and it's not going to cause some unjust result and it flowed from a breach of fiduciary duty, that's going to be fine. You can use the tracing remedy in order to obtain that benefit. Now, where things get complicated, and again you will be assessed on this, is actually the scenario that I mentioned in the final slide for those that did trust accounting. It's the mixing of funds. That's where things can be complex, because when you're taking money that's been obtained through a breach of fiduciary duty and putting it into an account, into another account that already has some money in there, particularly then when later on money comes out and money comes into that same account, it's difficult to really identify, at least from a common sense perspective, which bit of money is yours and which isn't, because money, as we know, is a fungible thing. $1 is no different from any other dollar. Assuming here we're dealing with bank accounts. And you might recall those that did trust accounting, where you have your general trust account is one physical bank account. Money goes in, money comes out, and you have to reconcile it regularly. It's one account. And so if there is some form of breach and money's gone, leaving aside the Fidelity Fund for solicitors, then you use the rules that I'm about to go over in order to resolve that. So the starting point is a case called Re-Hallett, or Re-Hallett's estate. And it's something of a legal fiction. It's this idea that if there has been a breach of fiduciary duty, or in other words, trust funds have been taken and moved and mixed with the trustee's personal funds, the starting point is when things all end up going to court, the courts will deem that particular trustee to have been intending to spend or withdraw their own money first. And it's something of a legal fiction, because the way they phrase that is that, oh, we presume that the trustee has acted honestly. Clearly they haven't. It's a legal fiction. They've taken the money and put it in their own account. So, for example, say a trustee puts $10,000 from the trust fund, and they move it to their personal account, which has, we'll say, $1,000 in it. If they then go and earn some money, get paid their wages of, we'll say, another $10,000, then they go and spend $16,000. Okay, well, we've got $5,000 left, assuming I've done my maths right. The courts will deem that that trustee in that situation has spent their own money first. And so all $5,000 that's remaining will go back to the beneficiary seeking this particular result. If there was more, for example, if the trustee had only spent $6,000 and there was $15,000 sitting there, then it would be $10,000 that would go back. That's the rule in Re-Hallett. Okay, there's a couple of rules. If we just get our head around them now, it's going to save some heartache later. It is an old school set of rules. These are old rules. They're determined by judges not accountants or actuaries or software developers. Okay, so that's the starting point in rehaul. When you're answering exam questions, that is the starting rule that you need to use. Assume that the trustee is acting honestly. Now, there's two exceptions to that. One is the intermediate fund rule. Because rehaul involved exactly the scenario that I talked about. In that situation, though, in rehaul that was a solicitor, and he I think he became bankrupt and died. And I believe might be Oatway's case, the exact same thing happened. Solicitor went bankrupt and died. But the thing to note here about this intermediate amount is that the legal fiction in rehaul it only goes so far. And in this James Roscoe and Winder, again, similar situation happened. It took some money from a trust account, put it in, mixed it with their personal funds, then started spending it. And what the court said is that if the amount is reduced below what the sum of that trust money is at a certain point in time, the amount that can be claimed back using tracing is capped at that amount. So going back to my original example, if there was you've got $1,000 in your personal bank account, $10,000 of trust money ends up in your personal account. In other words, it's mixed together. If the person had spent $6,000, just frittered it away, the balance is now down to $5,000, of which it's all deemed. The intermediate balance is actually $5,000. That caps the amount that you can actually seek using the tracing remedy. It's a quirky exception to that. That's the James Roscoe, Bolton and Winder. So that if the amount falls below what the trust amount, what the sum that you're trying to trace, if it falls below that amount, and I know this sounds really unintuitive, that will actually cap the amount that you can use the tracing remedy to recover. That's the intermediate balance rule. That takes a little bit of getting your head around. So even if you've gone, they've spent this money and they've put more money back into it, it's going to be capped at the lowest point that it went to. And in Oatway, this idea of taking money out and spending it on assets. Earlier I talked about this idea of this transformation step. The transformation step, those assets can still be recovered using tracing. So that if money has become mixed into a trust account and then it's been expended on assets, those assets can still be counted. In other words, that you can still trace to those assets as part of that process. In most situations, you'd want the money first. The person bringing the action can trace to those assets that have been purchased from an account where funds have been mixed. So if in this situation, again, there was $1,000 of cash, $10,000 of trust money has gone into there, and the person has gone and bought a $10,000 car, or not an example, $10,000 worth of shares as part of that, the beneficiary can go and ask for the tracing remedy to go on either all or a part of those packets of shares. So in other words, they could ask for the $6,000 that's sitting in the bank account and $4,000 worth of shares to trace that through to what the final asset is. Okay, so Hallett is the starting point. That's the easier one. then we have to look at Clayton's case. All right, this is an old rule. There's an old rule and can cause some drama. The reason for that is where there are two or more trusts, monies that have been moved or mixed together in breach of fiduciary duty, mixed together in the same account. The default rule is the first one that went in was the first one to come out, the FIFO rule, the rule in Clayton's case. And you could imagine that can cause some problems. It is actually the default rule. So if you're analyzing these problems, hypothetically, on the 16th of November, this is the rule you're going to have to start with. So going back to the example that I had before, $1,000 is sitting in a personal account. If $5,000 from one trust comes in, and then a day later, $5,000 from Trust B comes in, if the trustee starts withdrawing money, so they take $6,000 out of this account, the rule in Clayton's case says that if we were to go to court right now, the person who had the money in Trust A gets nothing, the person in Trust B gets $5,000. That is how it works. It is very, very harsh. Again, it may seem very, very unintuitive to you guys, and it has had relatively recent cases that have gone through and sort of reflect and say, look, this doesn't work in many situations. But that is the default rule. So the rule in Clayton's case, we'll have to go and explain this, is that where multiple trust funds are mixed together and then money is withdrawn, it's deemed to be first, again, applying rehalats, first withdrawn from the person's personal funds. So in other words, if there was already that $1,000 in there, that gets dissipated first. Then the balances will be reduced from the first money that went into the account. That is just the way that rule works. I know it seems very unintuitive, but again, I seem to say this a lot in my subjects. Lawyers, and particularly judges, are not accountants. It has had some criticism. I'll bring that up here, which is going to be your final slide of content for this subject. Everyone's all happy. Look at those smiles. And that is that idea in some situations, it makes no sense. I come from a software background. The concept of doing overnight data loads, where the money's all come in during the day, you have one load of that to send off to the bank at night. It makes no sense at all, the rule in Clayton's case, because the order that you send them in could be anything. Could be last name, could be first name, could be customer number, could be the natural order that they set in the database file, could be anything. It makes no sense in many situations. And so here, the French Caledonia travel case, in that situation where people had paid into a travel agency firm that went broke, they said that the date that money was paid, given that the contract dates were different, the money that was paid was going to be different and paid in multiple installments and paid often via third parties, like the Visa company would have paid the money in, or paid through institutions like JCU would put money in, not in this case, but those sorts of institutions, that it made no sense to use the rule in Clayton's case when trying to determine how to repay all of the beneficiaries here, the people that had prepaid for travel. There they did it as pro rata. You just get a certain number of cents to the dollar. And that is the final piece of information that you guys have to put in your heads. Well, that's not strictly true. We're going to do some workshops for this subject as well, but certainly in terms of the lecture content, I'm going to wind it up there. And we'll obviously going over things in shoots. But that's, in terms of your lecture material to revise, that's the end of that. So you can breathe a sigh of relief. I apologise that this sigh of relief would have come 1 week ago, but we had to have the extra test. Again, apologies for that. And I hope for those listening on the recording that this has been useful. And we're going to have a short break, and then we're going to go across to the tubes. So thanks all. I'm going to turn the stream off, and I'll see you over there in a bit.